Okay, good day, sir. My name is Ricky Sampitan. I am one of your students from base Criminology 4B. I am going to discuss the most important or salient part in this Rule 110 to Rule 126. In Rule 110, which is the persecution of offenses. In Section 1, it said that the institution of criminal action shall be instituted as follows. The first paragraph is letter A. For offenses where a preliminary investigation is required present to Section 1 of Rule 112 by filing the compliant with the proper officer for the purpose of conducting the requisite preliminary investigation. In paragraph A, that it said if there is someone who will going to file a case, she or he uh, go to the right officer or proper officer to proceed into or conduct into a preliminary investigation. And letter B or paragraph B said that for all other offenses by filing the compliant or information directly with the municipal trial court, municipal circuit trial court, or the compliant with the office of the prosecutor. So, uh, some case that if there is a person who were going to file a case, they going directly to the uh, MTC or the municipal trial court, and the others will going directly to the office of uh, the prosecutor. And section 2, which is the compliant or information, the compliant or information shall be writing in the name of people of the Philippines against all persons who is responsible for the offense involved. So uh, it must be written of in the name of the Philippines or in the name of the people of the Philippines and against all persons who is involved from the crime or the offenses. And Section 3, compliant defined as a compliant is sworn written statement charging a person with an offense subscribed by the offended party and any peace officer or other public officer charged with the enforcement of the law violated. So that is the Section 3. And the Section 4, it, information defined. Information as accusation is writing charging a person with an offense subscribed by the prosecutor and filed with the court. So it will be subscribed by the prosecutor, and the prosecutor, he is the only one who had the authority to file into the court. Okay, let's go into other section of the Rule 110. So let's go into section 7, the name of the accused. The compliant or information um, must state the name and surname of the accused of any appellation or nickname by which he has been or is known. So in section 7, it said that you must write the name of the accused, even the surname or other nickname of the accused. If his name cannot be ascertained, he must be described under the fictitious name with a statement that his true name is unknown. Okay, let's jump into section 9, the cause of the accusation. The acts of omissions complain of as continuing the offense, and the qualifying agreement circumstances must be stated in ordinary and uh, concise language, not necessarily in the language used in the state, but terms sufficient to to enable a person of common understanding to know what offenses is being charged, as well as its qualifying and aggravating. Okay. In section 10, the place of commission of offense is one of the most important in Rule 110, which is the prosecution of offense. And that's all the most salient, or some of the salient or important from Rule 110. Okay, so in Rule 111, which is the prosecution of civil action, Section 1, uh, this institution of criminal and civil action. So when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with the criminal action unless the offended party waive the civil action. Okay, reserves the right to institute the separately, or institutes the civil actions prior to the criminal action. Okay, so uh, the reservation of the right to institute a separately civil action shall be made before the prosecution. So it shall be made before the prosecution of starts presenting its evidence. So, and under circumstances affording the offended party a reasonable uh, opportunity to make such of reservation. Okay. In Rule 111, it's all about the prosecution of the civil action. It's all about the prosecuting the actions of the offenses of the accused and the crime they committed. So let's go or jump into Rule 112, which is the preliminary investigation. Okay. Preliminary investigation is one of the most important. It said in Section 1, a preliminary investigation defined when required. Preliminary investigation is a required or proceeding to determine whether there is a sufficient ground to engender well-founded belief that a crime has been committed and the respondent is probably guilty thereof and shall be held for a trial. So the most, or one of the most important of processing the filing of a case is the preliminary investigation, because preliminary investigation is, it can be proved that there is a probable cause or there is a reason that this case will be heard into the court. Because of the preliminary investigation, we will know that, or there is a uh, cause of the crime committed. So in section 2, officer authorized to conduct preliminary investigation. Okay, these are the officers which is the authorized to conduct a preliminary investigation. The following may be conduct preliminary investigation, which is in letter A, which is the provincial or city prosecutor under assistance. Okay, the one of the authorized to conduct a preliminary investigation is the provincial or city prosecutor under assistance. And letter B, the national and regional state on prosecutor. And the other officers, regional state, the other officers as may be authorized by law. Any kind of the officers which is authorized by the law. In Section 3 procedure, the preliminary investigation shall be conducted in the following manner. So these are the manners of um, if you are going to conduct preliminary investigation. So these are the manners. If you read the paragraph letter A and letter B and letter C, okay, that's are the good or the manners of conducting a preliminary investigation. Okay, that's all for the Rule 112. Let's jump into Rule 113, which is the arrest. In Section 1 defines of arrest. Arrest is the taking of a person into a custody in order that he may be bound to answer for the commissions of the offense. So, uh, in I know all the criminology students know what is the arrest. Arrest is a taking of a person into custody. So to answer the commission offenses or may have the interview. Section 2, arrest is how made. So how do we made the arrest? An arrest is made by the actual restraint of a person to be arrested, or his submission to the custody of the person making the arrest. Nor violence or unnecessary force shall be used in making arrest. So there is no necessary force to use by making or conducting an arrest to a person which is the um, liable for the crime happened. In section 4, which is the execution of warrant. So this is the execution of warrant. The head of the office to whom the warrant of the arrest was delivered for execution shall cause the warrant to be executed within 10 days. So the 10 days will be the warrant will be executed in 10 days from its receipt to uh, within 10 days. After the expiration of uh, of the period of the officer to whom as it was assigned for execution shall we make a report to judge who is issued the warrant in the case of his failure to execute the warrant. He shall state the reason or the reason why he did not execute or do it or make the warrant. And that is the Rule 113 is all about the arrest. And Section 5 is the one of the most salient part of this rule. Section 5, arrest without a warrant when lawful. Okay. A peace officer or a private person without may without a warrant arrested or arrest a person. In paragraph A, it said, when is presents the person to be arrested, is actually committed or is attempting to commit an offense. So if you or I am the one of the officer or the law enforcement, uh, I am allowed or authorized to execute a warrant of a person even I don't have the warrant. I can uh, arrest a person if he is uh, going to make a offenses or attempting attempting offenses. Okay, in paragraph letter B, when offense has just been committed and he has probable cause to believe based on a personal knowledge of facts or circumstance that the person to be arrested has committed it. So that's all for the Rule 113, the most or important or salient part of this Rule 113. So now let's jump to the Rule 115, which is the right of the accused. So in section 15, in Rule 115, uh, rights of the accused, in section 1 it said that right of the accused at the trial. So these are the rights of the accused during trial. In all criminal prosecution, the accused shall be entitled the following rights. So during the uh, trial, the accused must know his rights before he uh, going or before he enter the trial. Okay. In paragraph A, to be presumed innocent until contrary is proved beyond reasonable doubt. And that is the paragraph A. Paragraph B, to be informed of the nature and cause of the accusation against him. And letter C, or paragraph C, to be presented and defend in person, any by counsel at every stage of proceeding, from the arraignment to promulgation of a judgment. Okay, the accused may, however, waive his presence at the trial pursuant to stipulation sets for his bail. So, in Rule 115, it said it's all about the right of the accused and what is his right or her right to uh, engage into a trial. So, in Rule 115, the accused must know his rights, um, his right to when he is in trial, he must know all of the rights that he or she need in trial. And Rule 115 is all about the rights of the accused. So if you read the Rule of 113, there is uh, many types or many rights of the accused during trial. But in Rule 118, in Rule 118, which is the pre-trial, in Rule 118, it's discussed or it says that um, the accused or the prosecutor must be in the pre-trial because it is a mandatory for a trial that the accused and his prosecutor will be there on time. And because pre-trial, that is the time where we lay downing all of the kinds of evidence. So in Rule 118, the pre-trial, the accused and the prosecutor must be there because that is the time where we going to present some of the evidences, and failure to present their evidence during free trial, it will be not be considered during the trial. Okay, so if I am the prosecutor of the accused, but I am not in the pre-trial, my presence is not in the pre-trial, and I did not present my evidences on time. So during the trial, my evidences, or I am not going to allow to present some of the evidences because evidences only present in the pre-trial. Okay, all agreement or admission shall be present during the pre-trial. So all agreement and um, admission will be present only in the free trial, and the accused must be signed and the prosecutor. So the accused and the prosecutor must sign all of the admission and agreement during the pre-trial. So that is Rule 118. It's all about the pre-trial. And Rule 119, which is the trial, the most important of uh, prosecuting, or the most important in trial, which is the Rule 119, the trial. Okay. Uh, After the pre-trial, uh, the court will give 10 days to uh, accused to prepare. It is time to prepare for trial. So the court will give 10 days um, to the accused to prepare himself with his prosecutor. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare trial. The trial shall commence with the 30 days from the receipt of the pre-trial order. Okay. Continuous trial under the termination postponed. The trial once commenced shall continue from the day by day as far as practicable until terminated. It may be postponed for a reasonable period of time for a good case. Shall be after consultation with the prosecutor of defenses. During the arraignment, the accused must in uh, arraignment. So arraignment or pre-trial, the accused must be the presence of the accused must in there. Okay. Okay. In the role 121, which is the new trial or reconsideration. New trial or reconsideration at any time before a judgment of a conviction became final. The court may, on motion of the accused or at its own instance but with the consent of the accused, uh, grant a new trial reconsideration. So in Rule 121, it's all about the reconsideration of new trial or new trial reconsideration. So it will be happen after the trial. So the accused must appeal or file for the new trial reconsideration. The court will give you 15 days to make more or file or appeal. And if you do not make move within these 15 days, the judgment of the court will become final. So after the judgment of the trial, the court will give you 15 days to appeal or to uh, file of the new trial reconsideration. And if you do not make a move uh, inside of these 15 days, the judgment of the trial will be on final. Okay. Ground for reconsideration. The court shall grant the court shall grant consideration on the ground errors of law or facts in judgment, which requires no further proceeding. Uh, there are two types of possible errors of the ground for reconsideration. Is the first is the error of laws, and the second one is the errors of facts. So in errors of law, maybe there is some error of using or comparing the law, and it's also the same of the facts. Okay, in Rule 122, it is appellate uh, process. When we appeal, when the accused is lost his case where he or she appeal in the higher court, which is the RTC, and denied by the RTC. So we have two types of appeal or jurisdiction. The RTC, I mean the appellate jurisdiction, which is the petition for review, and original jurisdiction, which is notice for appeal. That is in Rule 41 and Rule 42. Okay, so in last, the Rule 126, which is the search and seizure. Uh, One of the most important or salient in this Rule 126, which is the search and seizure, search uh, warrant defined. As a search warrant is an order in writing issued in the name of the people of the Philippines, signed by the judge and dictated to a peace officer, commanding him to search for a personal property describes there and being if before the court. So in Rule 126, which is the search and seizure, if the search warrant was signing or uh, released to judge by the judge to a police officer or one of the officer who is authorized to conduct the warrant, it must be written people it must be written of the name of the people of the Philippines. Yeah. And then personal property to be seized. So personal property to be seized. A search warrant may be issued for the search and seizure of a personal property. Uh, the letter E is subject of offense and more, etc. And paragraph B, stolen or emphasize and other proceeding, fruits of the offenses. And the paragraph C is use of intended to be used as the means of committing offense. Okay. Uh, the validity of the search warrant is in 10 days. So as we read the previous rule, so the validity of the search warrant is only 10 days. And after 10 days, if the officer failed to make or to do it, the search warrant, it will be make or it will be given back to the judge and report of some reasons why did he not do it or make the um, or search warrant. Okay. If the manner of the if the uh, owner of the property will not allow you to search or proceed to search warrant, you are allowed to use force to enter the property. Like for example, if I am one of the officer which is has a given authority to conduct the search warrant, and if the person uh, uh, who has be conducting search warrant, if he refuse me to enter his property, I am authorized to make a force to conduct a search warrant. Okay, uh, it is my right to break door or window to effect the search warrant. So I have given the authority to use force to conduct some of the uh, warrant. Okay, search of house, uh, room, or premises to be made in presence of two witness. So if you are conducting a search warrant, you must be have two witnesses, uh, whether the barangay captain or any kind of barangay officials. At least you have two witnesses of conducting the search warrant, and that's all. That's all for the Roll 126.